just going to put myself on mute. Good morning, everyone. This is Sandhya Iyer from the HR department, and this is your roundtable, which is conducted once every 2 months. We've got our local employment lawyers and HR consultants attending this meeting, as always. Today's discussion is mainly going to be revolving around some of the pending changes that we are expecting in the world of employment law, given the upcoming elections and the what it looks possible that Labour is going to be the ruling party going forward. So obviously there's a lot of material out there, and we can't cover everything in this 1-hour call, but I've just to start the conversation, I will be putting out some sort of feelers out there, and it'll be nice to get the discussion going then. So really today I'm going to be the 3 main things that jumped out for me when I looked at various pieces of material about what Labour is planning to bring. And I think it's going to be no surprise that Labour is going to cull down on the tradition and practice of issuing 0-hour contracts. Knowing how Labour tends to function, I don't think they're going to be too much in favor of that. So it'll just be good to understand whether that's going to impact your clients, your small business, medium-sized clients, and larger businesses. In what way do you think it's going to impact them? How is it going to be received? The other thing that really also piqued my curiosity a little bit, because I haven't worked on such a case previously, but the Woolworths case law, where it is expected, it's obviously not yet law, but it is expected that Labour may well say that in order to decide whether there should be whether the people who need to be consulted with is more than 20 or not, you've got to consider all your entire headcount in the business and not just restricted to a specific branch. So again, I haven't worked on a case where we haven't had to restrict it to a certain branch that is impacted. So it'll just be good to have insights on whether anybody here has worked on similar cases and what the challenges were. And the third thing I identified was tribunal deadlines are going to be extended to 6 months vis-a-vis for employees to raise a claim after dismiss from termination date. Currently they have up to 3 months to bring in a claim, and that's going to be possibly extended to 6 months. So I've put it all out there to you in one shot. We can start with the 0-hour contract. I'd be really, really interested to know your thoughts on how you think this is going to be received by your clients, because I'll be honest, I have quite a few clients who use it. Yeah, over to you.
I've just posted a link to a chap that I know Sandhya or know of, a chap called Darren Newman. Don't know if anyone else knows of him. He often speaks in the HR group that Sandhya and I are part of, and I quite like his approach. I think he's very pragmatic and very sensible, and he writes a very good blog. And there are in there there's an article about 0 hours contract, and there's an article also about the trade union legislation change or potential trade union legislative changes. One of the things that he talks about in the 0 hours contract is that, not surprisingly, is that 0 hours contract covers a multitude of sins. And I think generally there are 2 issues. One is it the predictable hours issue, or is it the fact that you're on call? So if you're someone who wants some ad hoc work, I don't know, as a film extra or something like that, and you're very much in the driving seat, then I don't think they're after those. But it's how do you get that detail? And as he said, well, if you buy a 0 hours contract, is there a minimum number of hours? So what if you say to everyone, right, we'll guarantee everyone 1 hour a month? That's not 0 hours, but it doesn't really help. So I haven't seen or read any detail on it, and my only impression so far is that until the Labour manifesto comes out, and even if when it does come out, I'm not convinced it's going to have a ton of detail in it, because there's no upside for them putting in a ton of detail they don't need to.
No, and that is what I have noticed is missing. Obviously, we can always give them, give them some slack saying it's early days and they're not even, they haven't even come to power yet. But it just seems like these changes it reminds me of the guidances that were coming out during lockdown, and it really frightens me. It's a bit like trauma that I just don't want to relive.
Yeah,
I'm really
I feel
nervous, and
exactly
that's
the
why I put it
same,
out there
Tanya.
now.
I have to say, I'm not sure I agree totally. I think the dynamic is completely different. And I think that was, clearly driven for a different reason, and it was being clarified and updated on a pretty regular basis. But at the moment, I think we're going to ban fire and rehire, we're going to ban 0-hour contracts. Generally, they've rowed back from most of the early commitments, but even then, the detail could mean this or it could mean this. And the the general approach is we like good things and we don't like bad things, and there isn't much more detail than that. I mean, I think there's a general direction, which isn't a surprise. I mean, if you look on the trade union stuff, none of that's a surprise. But I'm not sure. I have to say, I'm not convinced the 0-hours contract are going to be massively changed.
My thought on it was they're going to have to do something else, surely, because if you can say, yeah, okay, let's ban 0-hours contracts, but there's going to have to be an alternative, because I've got a number of clients who use 0 hours and rely on 0 hours and aren't actually using them in a negative way. They're actually being used in a very positive way, because they give a lot of flexibility to people that, for example, this week it's half term, people might want to work less hours, but actually they might work 15, 20, 25, 30 hours the week after, because there's always work to do and there's always work to be done. So, and there is that flexibility in the workforce that people like. There's also, of clients I've got where they don't know necessarily what work is coming on. So it is more of that on-call relationship. And you employ people in, out in the field or whatever, that you do need that sort of 0 hours flexibility. Event staff and hospitality and that sort of thing. And so there's always going to have to be some alternative, but I don't know what that alternative looks like. I mean, before they made the change to the holiday ruling, and there was that whole, again, it brings back a bit of trauma about holiday calculations for 0 hours employees based on the 52-week, and then they've changed it to this year to actually make some sense. I was actually encouraging my clients, they're saying, well, we want someone on 0 hours. I was encouraging them to put even a bare minimum of hours, like 5 hours, just to be able to have something to kind of work that holiday around, because it kind of made more sense than doing purely 0 hours over, whatever period that they worked. But it has to be on that case-by-case basis. And I think the small business world needs that flexibility, I think.
I think you hit the nail on the head, Gemma, because one of the frustrations that HR department, we find is that when laws are passed in Parliament, they're very blindsided by what goes on in the SME world. It's all about big corporates, what comes out in the news and the headlines in the newspaper. And I think the biggest sectors that are going to be impacted by not having 0 hours at all, if that ends up being a reality, it's going to be the care sector for sure. It's going to be hospitality to some extent. At least hospitality, okay, they could be working shifts. It's all a bit structured. Okay, I get that. But care is going to be impacted big time. And then businesses dealing with perishables, funeral directors, these sort of businesses are really going to be hit badly if you just completely took away 0 hour contracts. And I just hope, like you say, they come up with solution B and not just totally score it out as an option. What does everybody else think about that?
I think that's what Gemma's. I'd agree with Gemma. I think it's not about the 0 hours. It's about the the precariousness of unpredictable hours. And the trouble is one person's precariousness is another person's flexibility. and I don't have an answer, because I think, you know, we all, you know, my daughter's, you know, her daughter works in hospitality when she's home from university, and very often it's, yeah, you know, you're coming in on Tuesday for a 9-hour shift, and then you turn up and, oh no, we only need you for 1 hour. Now, luckily, we adjust her rent slightly based on that, but not very much, obviously. But I think it's that sort of thing that is probably more the issue, or the sign off when, you know, clock out when we're not too busy. I think it's probably those things that more people dislike, but obviously not the businesses that run it. I'm curious, from the 3 solicitors on the call, what you're seeing and hearing from your clients on this.
Do you want me to
Please do.
Yeah, I don't come across it very often, because I actually find more of my clients are switching across to employing workers, and you have that sort of hybrid or innominate sort of situation where you're trying to work out somebody's status as to which side of the line they, you know, and where the divide is drawn. But in so many instances, they're treated with the same protection, and they have the same rights, apart from unfair dismissal, you know, in maternity leave and holiday pay and so forth. So increasingly, I think that world is narrowing. I think it's a very political issue, because I think the politicians see it as an abusive relationship, and that's why they want to reach out and restore balance insofar as that goes. And I'm not sure in the business world it happens like that. I think it is about flexibility, and it is about meeting changing needs in a different world, you know, and increasingly since, you know, post sort of pandemic, business works in a very different way and has to be more dynamic. And I think individuals want a different work-life balance. And often that's not about the usual commercial, abusive, one-sided relationship with the power all on one side. It is actually often very much more balanced and nuanced than that. So I'm not seeing it very much as a problem. My clients, I think, find it very, very useful. In fact, often that they'll ask employees to step up and work more hours, and sort of, you know, that's when that sort of mutuality of obligation gets sort of slightly strained, when somebody says, thank you very much for thinking of me. Actually, I've got things to do. You know, I'm seeing the grandchildren, I'm playing golf, or it's my wedding anniversary, or, you know, I just frankly, it's a nice day and I'm going to do some gardening, or whatever it might be. But thank you, but no, I don't intend to do any work today. So actually, I think what I'm seeing more is the difficulty and the frustration that employers are facing, because it's very well having a very flexible hybrid workforce, but actually it's difficult to maintain not discipline but consistency, should we say, because it's about service delivery from an employer's perspective. And there's sometimes a mismatch, but I'm not seeing there's an abuse there. Perhaps those cases don't reach me. I don't know, but it's about the effect and the delivery of service, which is more problematic, or certainly from the employer's perspective.
Agreed, definitely. Or at least where, even if I think there was, as you say, if it is being an abusive relationship, although there is no excuse for it, I don't think there is awareness on the part of the employer as to what's going on, you know, unless, but once they start engaging and seeking advice, I think things do get ironed out. And in the business world, it's done like the way you and Gemma have explained it, have described it. Really, it's purely on a need basis to run the business efficiently and really meet fluctuating demands for work. Yeah. The second point, if everybody's happy to just move on to the second point, which I just thought I'd raise, is about the redundancies. Now, for collective redundancy to decide whether we should have, whether the numbers we're talking about is 20 or more. Has anybody here worked on cases where a client had or a business had a number of branches or say shops or locations prior to the Woolworths case? And does anybody have experience of leading a redundancy consultation in those cases? Because I don't, and I was just curious to know how. I'm just thinking, I mean, where we have a client and then they've got a branch somewhere in Wales, which is being managed by a family member, and then they've got a branch up in Birmingham, and then they've got a few other branches in the London periphery. It just makes no sense to sort of,
No.
consult with all those locations. It just doesn't. Thanks, Mike. You've popped something across. Thank you.
Back in my retail days, but that was a long time ago. I do remember doing a redundancy consultation, and it was within the stores that we were working in. And I think where we had multiple stores in one town, we did do a consultation within that group, because there was the mobility, but it wasn't across the whole country. It was, we've got a concession and a main store in Oxford, and so we're going to consult with those two branches because the concession's closing. And actually we then moved the two stores, sort of merged the two stores together, but that was in a
Same geographical area.
Yeah.
Yeah.
It does. We definitely didn't do it across the entire country.
Yeah, I think I've been trying to read up on case laws or anything, or not even just any kind of cases where people would have worked on such a large, sort of geographical spread with multiple branches. Be interested to know how they'd go about it if they did. And anyway, I suppose it's not something to worry about, but hopefully we'll get some detail around that.
I'm assuming legislation is never going to work for all businesses in all manners, but I think again it is a simplistic approach, and it's going to be down to the detail. But I'd have thought this is an easier one to put in, because the impact is going to be quite latent. It's not suddenly going to impact like day one flexible working rights or removing caps on unfair dismissal. This is something that's only going to really affect a relatively small number of businesses, but a potentially bigger number of people at some point in a relatively hidden way, unless it's a Woolworths type thing. So I think.
See, you say it's a relatively small number of businesses, Mike, but I don't know. I mean, I think when I think of my life in corporate and in the SME sector, number of businesses come to mind which have branches spread out in different areas. So I wonder whether, again, we don't know numbers.
I understand it definitely will affect a lot of individual people, but it's not like saying the minimum wage is going up, or flexible working day one, which is every single person across every business, every location across the board. Yeah.
I see what you mean.
And I'm not saying there won't be an impact, but I think the impact is relatively hidden.
Yeah.
It's quite interesting, isn't it? Because if you're looking at collective redundancies, you're still looking at zeroing in on a pool of potential candidates for selection for redundancy. And if your pool is demarked because that branch is going to close and cease providing services, or is expected to do so, usual stuff, but you've got, say that's in Kent, but you've got another branch in Liverpool, it seems to me that the rationale for involving staff geographically distanced falls away. I mean, I just often it just doesn't seem
Okay.
sensible,
Yeah.
other than when you're looking at the reasonableness of the decision to dismiss somebody on grounds of redundancy, as opposed to the consultation, and that may be putting the, you know, the sort of swapping it around, because I can see at that point it might be worthwhile asking, is there anything that can be done somewhere else? Because that's part and parcel of the normal decision-making process, to see if there are any alternatives that can reasonably be explored before implementing such a decision, because of its drastic consequences. But to me, it might be entirely reasonable if you've got two depots in close proximity to broaden it out. But it might have to be looked at on ordinary unfair dismissal principles, on what is fact and degree, and what is sensible and what is reasonable in the given circumstances, as opposed to sort of a blanket, you must consult with everybody. Because sometimes it's going to lend itself to sort of a very large employer with deep pockets and a unionized workforce. It doesn't lend itself very well to loads of different offices, particularly when you've got people perhaps not necessarily working in at a branch or an office, but working more remotely, because they could literally be all over the country. Possibly that's a good thing or a bad thing.
Yeah, interesting. Again, I think, like we were talking about the 0-hour contract, I don't think you can have one rule fits all kind of thing, isn't it? There's got to be tiers in the way you address what, or maybe define what you mean by geographical location.
Yeah, I mean, most people would normally, I mean, you mentioned sort of mobility. Most people would think it's nonsensical
Yeah.
to ask if they would like, it's one thing to say, would you be willing to relocate? It's another thing to say to somebody, are you able to commute on a daily basis? And that's where it gets, well, A, there's the cost, B, there's the timescale, cost, linking, work-life balance, however you want to define it. But there's a tipping point where you say that's no longer practical or sensible to even ask that. It becomes vaguely insulting, stupid. It's not actually adding; it's subtracting from the process. So one size fits all will be very difficult to implement.
Absolutely,
on
yeah.
a commonsensical basis, I think.
Yeah, absolutely. But again, I think where the detail is lacking, and you just read these things on their manifesto and you go, how is this even going to pan out? And that's what I think I tend to be, you just kind of look for examples on how things were done maybe before these sort of this case law came into effect. Anyway, Mike and Chris have both touched upon the cap on unfair dismissal. So why don't we talk about that? And Mike, did you want to touch upon that a little bit?
Only that Labour have said they're going to remove the cap on unfair dismissal.
Yeah.
I'd be curious what everyone else thinks. My wonder is twofold. One is that the number of cases that are someone's suddenly going to claim for £300,000 versus £95,000, I'm not sure is going to be huge. What I do wonder, though, is if, obviously we're talking about higher paid individuals here, but still, I think it may potentially diminish the number of claims for discrimination or harassment or whistleblowing that are currently uncapped, where people lump in a claim for those as well as an unfair dismissal. I would suspect it could potentially diminish those multiple claims and allow people to focus on just an unfair dismissal claim, especially during the negotiation or with employers. I mean, I think in most cases, I think it's an unusual case where people are claiming multiples of their annual salary or trying to negotiate that. So I think there's an element of it being a bit totemic, but I also think it will potentially simplify claims. But I'd like to hear other views, because maybe that's not the case. What does everyone else think?
I have to be
Natasha
honest
and
and
Joe,
say it's
we
not
haven't
one
heard
I've
from you.
done.
I'm sorry,
No,
Gemma, go ahead, go ahead.
no, I was just going to say it's not one I've done a huge amount of reading into yesterday, although I was fairly horrified when I heard that they were taking away or putting in a day one right to claim unfair dismissal as well as the other one that I've heard. But yeah, I'll leave it to those that might have heard more to comment.
I just find it interesting that Mike thinks discrimination claims will decline if the cap on unfair dismissal is taken. I'm not sure that's going to be the case. Yes, but I also see your viewpoint that it's going to streamline and simplify claims to that extent. But I think the underlying factor may still be, because I just find, especially when it comes to short service dismissals, discrimination tends to be the most common factor, the most common reason for alleging.
Well, it would be, because they can't do unfair dismissal.
Exactly. But again, if what Gemma has just said, where it's going to become a day one, right? That would then have, I don't see why they would not allege discrimination even then. If it's a factor, it's a bit like saying, it's an additional line item in your claim, isn't it? So for example, where an employer hasn't issued a contract on day one, on or before day one, yes, nobody's going to go and raise a claim just for that. But if you can lump it under a bigger claim as a separate line item, people are going to do it. So I don't think discrimination that's just my view. I don't think it's going to decline. I think it'll just still get added as a separate line item.
I think there are definitely people who are advised to chuck everything in, but I also think, and there are definitely some of those, but I also think there's a lot of people who get advice which is focus on the specifics, and if it's genuinely an unfair dismissal claim, then that's the thing. I think, as I say, I don't think it's going to solve everything, but I definitely think it will change some. But I think it makes the bigger issue around, I mean, I personally, I don't think they're going to reduce it to immediate, because they've also said, there'll still be probation periods. Now, this is relatively vague, because then people will have a 1-year probation period. I would imagine it's more likely to go back to 1 year, as it was up until 2010, I would have thought, because otherwise they're going to scare the horses.
I would think that's right, Mike. I mean, for my 2 pennies worth, I think it's a quantum leap to remove any service level as a prerequisite for being able to bring a claim of unfair dismissal. I think that would be perceived as a severe risk to commerce and business.
Yep.
Because effective businesses will be very wary of recruiting people. And if anything, I would imagine the argument will go, they're going to be very wary of recruiting any sort of anybody with an ethnic background, strong philosophical belief, anybody,
Women.
Women, goodness me, I mean, and the list goes on, because anybody you think might be a potential claimant, you'll start, part of your interview process will not be documented, will be risk aversion. So I think probably that will be a hot potato. I mean, the starting point is unfair dismissal now. I mean, as from April, I mean, there's 3 remedies for unfair dismissal. Of course, there's the basic award, and if you've been there sort of best part of 20 years, that can be sort of whatever it is, 18 or £1,000, same as the redundancy. The capped compensation award maximum is now 115,000, 115. So that's a big chunky sum. That's not by any means de minimis, or capped at obviously the 1 year's wages. But you've also got the remedy of re-engagement and reinstatement. So you've got 3 effective remedies already. There was always supposed to be a distinguishing characteristic between an unfair dismissal and, say, stigma damages in a high court, or discrimination. And I think if you, the danger is if you lift the cap on unfair dismissal, are you going to start finding that people start lumping in with financial loss, injury to feelings, and exemplary damages in the form of discrimination? It will need a lot of thinking through, I suspect. Inevitably, you're going to increase the costs of the tribunal hearing. And the process be a lot more consideration. But still, if there's no issue for you, it'd be still very easy to bring a claim, and very difficult, or at least expensive to defend. So,
Or just a rise in more preliminary hearings, possibly, where most of them get struck out. To narrow it
or
down.
a lot of settlements, simply where, I'm afraid, in the usual way, you would sit an employer down and say, look, I need to explain to you how much this is going to cost. And the commercial reality is, if you settle now at anything less than the amount I predict and estimate is likely to cost you to be able to defend successfully, bearing in mind the risk factor you might still lose, and having incurred all those legal costs, you're probably ahead on points. So it's not a moral dilemma, it's simply a commercial exercise. And I would imagine that we'll see an escalation in settlement agreements on potentially claims that are completely unmeritorious, but it is not worth the push, because it's so difficult to strike something out. Once it's gone through the sift and the claim's been admitted, tribunal view would be, well, somebody's entitled to bring a claim. And it's very difficult to, in a forum which is being judged on unfair and unreasonable sort of principles, to actually get a weak claim struck out, because the starting point is the tribunal will say that individual has a right to pursue that claim. They have a right to determination as to whether or not their dismissal was fair or otherwise. So you get an awful lot of employers, I think, feeling they're being held to ransom.
I get that a reasonable amount now, because small businesses actually, the thought of going to a tribunal is so awful and so costly for them, that they actually go down the route of a commercial settlement, rather than risk going to a tribunal and lose a claim.
Yeah, absolutely.
I when I sort of act for any claimant clients, because I act for both, I think they do as well. I think there's a big consideration for them in terms of legal fees of actually pursuing a claim. And I know what you said, Mike, about people that chuck everything in, but I think they think, I've just got to give it the best shot I can to get something. And if there's the cap on unfair dismissal is not really sufficient, then actually that's a big reason why they do that, to try and maximize their position as far as possible. And I think a lot of people are put off pursuing claims because of the cost to them, and that what they might get back, the average unfair dismissal award is actually quite low in comparison to the legal costs and what their earnings might be. So I think it's interesting looking at it from a claimant perspective as well, that actually the same principles do apply as they do to employers in some cases, not always, obviously. It's going to be an interesting one. I think it's interesting that I agree with what you said about with it being a day one. If it is going to be a day one right, that does overly complicate the situation, which I don't think is likely to happen. I think you're right that a year is probably where we might end up think I read as well about the 6-month moving all claim, the limitation period to 6 months for all claims, didn't they? So yeah, so all of these, it's how they all kind of work together, isn't it? How they correlate ultimately, all the proposals that are being put forward, which ones are going to stick and work with the others.
I agree, Natasha. I cannot see them moving to a day one unfair dismissal right, full stop.
No.
You know, there's going to have to be some sort of concept of probation.
Mm.
Well, not there's going to have to be. I doubt. I don't think they'll do it.
No.
Why is that, Mike? I just think with Labour, it's more possible.
And no, I think politically, I think you might have seen that in the 2019. I don't remember the 2019 manifesto detail. You'd have seen it under Corbyn, but I doubt with Rachel Reeves and Keir Starmer you'll see that, just because they they are you know, they're making more overtures, you know, making contact with business much more than 2019 Labour did. I just can't see them going that level, because at that point, you know, business is going to be up in arms. I mean, you had yesterday 100 different business leaders all coming out in favour of Labour. You didn't have that at all 5 years ago. Just politically, I can't say it. I think
Well,
you know,
would be quite interesting. Sorry, Mike, I was just going to say.
No, sorry.
Forgive me. It would be quite interesting. Sign of my diminishing age, or my age. A thought sprang into my head. I couldn't stop myself, so forgive me. It's very interesting if you do align the unfair dismissal to say the redundancy period of time, which is 6 months. So you align those, which might not be an unreasonable change. Bearing in mind, if you're going to maintain the early conciliation and leave it to the last moment to conciliate, you conciliate then for say 2 or 3 weeks, and then you get your certificate, and then you have at least a month thereafter. You're beginning to now get quite a chunky, quite a long timescale, aren't you? That limitation has suddenly become 7 months plus. And that's quite a sea change from the idea originally. It was your 3 months minus 1 day. That was your long stop, and then you got early conciliation, which can move the goalpost quite considerably. So you might be able to change the nature of the protection that's afforded to employees, so that they're able to go away, see if they can mitigate, take advice, and approach things in a measured and deliberate way if they want to take advice or bring a claim. They're certainly not stampeded into doing that. They don't have to do it overnight. But the risk, looked at conversely, the risk from the employer's perspective is that that shadow is over them for a very long time. It's very difficult, for example, to move on and recruit somebody to replace the person that's been let go without possibly provoking a claim that it was the reason was a sham and it was actually to do with something else, when actually it may be in a perfectly legitimate reason, and sort of 6 months have passed and you've reorganised in the way that you have to.
I would have thought ACAS would be, if there's a consultation, ACAS will be telling the government, look, the tribunal system's already on its knees, it's backed up to the hilt. We really don't need more claims. You know, we need to find ways to be reducing claims. So I think, you know, ACAS is going to be wanting to recommend ways to avoid further claims.
I agree, and the one thing that might possibly lend itself to that adjustment, or at least maintaining the status quo, is to introduce an issue fee, and that will be the one thing the Labour government, I'm absolutely adamant, or as far as I can be certain, will not want to introduce in any shape or form.
Yeah, that's the only way to put a peg, you know, to sort of control that.
It would put the brake on, wouldn't it?
Yeah, it did actually, back in, until it got lifted. Was it 2012 it got lifted? 2013? I can't remember now. But definitely they saw a significant drop, isn't it, at that time?
Yeah.
But I think it's all part of the same sort of general approach, like the noises that have been made about flexible working and extending flexible working being a default rather than a request. I mean, to me, I still think that's going to be something that's going to sort of quietly be watered down. You know, again, an automatic flexible working, unless it's deemed impractical. Again, I just think there's going to be too many. I don't think they're going to want to be pushing business that hard right from the start.
I think we discussed this at the last session. Like, I can't remember, I don't think you were there, but the last session we spoke about flexible working changes that came into effect from April, given the fact that it's day one right, and there can be 2 requests now rather than just 1 in 12 months. And one of the things that I think some of the bigger clients aren't very much impacted by that, because like you say, if you're professional services, then yes, flexible working is the default manner in which your staff work. But where it comes to, it really again depends on the sector. There are some
Correct.
sectors for whom it just isn't feasible. But then what ends up happening is in those sectors, employees know that it's now a right and they want to exercise that right, which again,
But it's
for
only
an
a right.
employer
It's a right to request. So
yeah, it's a right to request,
I mean,
but
I know it's a
it's still
hassle.
an administrative
Yeah.
hassle for the employer, especially when you're talking about leaner teams and smaller businesses. The employer still got to put aside time, still got to, you know, engage with an HR consultant to ensure they're doing the right thing. So the process has got to be followed. Yes, you don't have to agree to it. So I think that hasn't gone down very well with certain sectors and certain employers. It has put more of a burden
Yep.
on the administrative side of things.
I think as well, similar to what we were talking about with the collective redundancy issue, it's a bit different. You're talking about particular businesses rather than sectors, but whilst it's a very, again, I think possibly a bit more of a political point, because a one approach doesn't fit all in this at all. And like you say, professional services, default working, remote working is already becoming the default, but to make it the default across all boards, like you say, the administrative problems are enough in increasing the right to 2 requests a year, in making it the default. Maybe someone in HR can enlighten me a little bit more. I'm sort of relatively new to the world of employment still, but like the onboarding process, if flexible working is the default in a huge amount of industries, it's not a possibility, let alone an option. So what strain is that going to put on HR?
I mean, one of the things that we tend to say in contracts is the employer reserves the right to withdraw a flexible working scheme at any point in time. But that doesn't matter. That is really irrelevant now, because you've made it a day one right, and you also said twice a year you can bring in a request. So that clause is really redundant now and quite useless, to be honest. So I don't think there's much any HR consultant or employer can do with laws like that.
No, but I think it's just remembering, as Mike says, that it is a right. It's not a given. So,
True.
you know, I've
True,
got
yeah.
a client that I know is recruiting at the moment, and I've questioned them about flexible working, and they've said categorically not. They want 5 days a week in the office. They are struggling to recruit for it. But you know, that means that someone could come into the business and say, day one, actually, I want to work 1 day a week from home.
Yeah.
So I've kind of given them that advice and said that is a possibility. But so, you know, bear it in mind. But equally, if they've got a business case that says, no, this is the reason why it is 5 days a week and it's 5 days a week in the office, but equally you don't know what that flexibility looks like, because they might say, well, okay, I can do 5 days in the office, but I want my working hours to start at 8 and finish at 4 instead of 9 to 5, in which case that's still a flexible working request because it sits outside of that pattern. It's just a slightly different pattern. But I'd kind of hope that if it was something like that, or if someone wanted that flexible working, they would have that conversation before they started employment, and that would have been part of that recruitment process as well.
It'd be interesting on that point, Gemma, because you might very well find down the line that candidates are slightly disingenuous or at least
I'm shocked, Chris. I'm shocked.
but
I'm
slightly
horrified.
secretive, or at least
I chose not to comment when Gemma made that comment because I thought, oh, Gemma, you're very lucky to have clients who get staff like that because I don't, surely. It always comes out of the bag after the
I'm
first couple of weeks.
I'm horrified at your cynicism, Chris.
well, in the same way, employers probably are very loath to ask somebody directly if they're suffering from a disability, unless, of course, there's a reason, because the employer only has staircases and there are no lifts, so they need to ask, do you have mobility issues? Not to prevent somebody being recruited, but so that they could work out where they would sit, where they would house them, and resources and the wiring and infrastructure around that. But otherwise, it's been, you're not going to ask somebody if they're pregnant. You're not going to ask somebody, and I wonder if you're going down that slope, because if you do ask and somebody says, no, I'm perfectly happy and willing. In fact, I'm looking forward to the opportunity to work 5 days a week in the office. Yes, count me in. I'll have 2 of those, please. And then they turn up on the Monday. So, by the way, would rather see. I quite like the idea of a Monday and a Friday off, please. And I also wasn't really thinking 9 to 5, because the structure is based. This edifice is supposed to be based on trust and confidence, but of course, it tends to be a bit of a one-way street if you feel somebody's been slightly duplicitous in the way they've approached that. But it's very difficult to pin somebody down. The other thing I was going to say, just in terms of a practical consequence, I think you're absolutely right. It is obviously it's a right to request, and you have to have an objectively justifiable reason to knock it back. But where I have seen it work quite well is the idea that you have a trial period. And you roll it out and you say, well, let's just suck and see, because we don't know. We have reservations, and it's going to be a business. Ultimately, it's a business decision. Well, why don't we sort of come to the table, see if we can make this work, but we reserve the position to review it in a month or 2, or whatever the appropriate timescale would be. And that looks a very deliberate, measured approach, a fair approach that
I'm not sure there's. I have to say, from my experience, I have rarely come across companies who start off with the we're not keen on it, and then move to, well, let's just give it a try for a trial, because I maybe different sorts of clients, but I think they generally come with the answer's no. And no, we're not going to do if we do a trial, then we're opening the door.
I have to agree with
I'm
Mike.
not saying.
Cases, in cases where the answer is no, it's not because the employer is saying no, it's because operationally it is just not feasible at all. And this is where I started. This is what I was saying at the beginning, that yes, it's a day one right to request, but it still does not take away the process that the employer has to follow, the time it takes, and the stress and hassle given everything else that an employer already has to take care of when running a business and managing staff. So it is just added to that burden for an employer, and it hasn't gone down well. But they have to deal with it. But no, we haven't put in trial periods simply because the nature of the business is such that it's just not possible.
I've only tended to do trial periods if there's a possibility that we think it will work. So if we think we're going to accept it, then yes, we will always do a trial period just to have that get out of jail card, if you like. But yes, I agree with you both that if it's an operational, it's not gonna happen, then I don't see the value in doing the trial period. To Mike's point, I think it opens the door to someone saying, well, look, I've been able to do it.
What it does do, I guess, is it shows that the employer's been open. At least it's not approached the discussion with a closed mind. And there's a world of difference between a business where you need people on the shop floor or cashiers or whatever it might be, but somebody else can be working within the same organization remotely, but it suits the employer to have them working in close proximity and say, for example, in an office or a retail environment. But where you can, or where the individual is able to make out a strong case that they don't have to be there, the employer's got some degree of risk if they simply just say, not going to do it. So the offer of at least a trial period avoids the criticism that you've just rejected it out of hand, and you've been very partial in your approach. If you can be confident as well, if you're devious, if you like, that it's not going to work, then you can use it and roll it out as an example as to why it doesn't work, because you have experienced it, you have tried it, and you've approached it reasonably, but nonetheless it's sort of it actually corroborates and shores up the defence to any such application in the future. So there may be reasons why it is a good thing to do, even if you're still of the mindset that it's a negative outcome that you're looking to achieve from the employer's perspective. And if the employer is generally neutral, because sometimes they're just sort of slightly old-fashioned, or they've not thought that through, but they just want to test the waters because they say, we don't mind, possibly. We just want to make sure there's no negative impact on business and the service we provide. So if you can work as effectively as well, and there's no diminution in service, what's not to like? So it gives flexibility. And certainly what it does do is it prevents ultimately the risk that you end up in a tribunal. And at that point, the judge looks across the bench and they say, why didn't you try it? And
In that example, Chris, would you set metrics for measurables, because it then becomes it can become a bit of a subjective thing, can't it, as to what that measure of success is? Because the employee could say, oh yeah, this is great and I think I've done all my work, but actually the business might see that differently because they've got different metrics to be able to measure that output by. Would you agree what those were up front as part of that trial period?
Yeah, Gemma, I totally agree. I think it's very important. I think it's still important. I'm not advocating that the employer should abdicate responsibility. Quite the reverse of that. They need to be very prescriptive about how this is going to roll out, what the parameters are, how it will be gauged, and it wouldn't work in every instance. I mean, Mike's quite right. I mean, if you've got an employer that is absolutely adamant it won't work, that's fine. But sometimes you need to be able to explain that to a wide audience. And it has been scrutinised in law. Saying you've tried it is a very good answer to that. But you're absolutely right. You need objective and justifiable reasons so you can test it.
Tricky one, isn't it?
Yeah, it doesn't work in every instance. I totally agree that you know, there are a lot of industries and even within certain professions there are instances where it just doesn't work. In my own firm, for example, we still have nature of private client firm. We have face-to-face meetings. We have a receptionist. We still get a lot of elderly clients paying by check. We have a cashiering department in the office. The solicitors can work fluidly and in a hybrid manner and all sorts of things, but we have professional obligations to supervise our work. So partners have to take turns at least in being physically present as well, or at least working different ways. So even in our own, my own situation, I can see there are layers where if somebody asked, could they work remotely, and it was my receptionist, I might struggle, even if I wanted to be accommodating, to say that could work, because I said, well, how does that work for us? You know, whereas somebody else might ask me, and I might very well say, that's fine, but I will judge you on your, you know, are there complaints? Is good service delivery? Does it affect your your billing and so forth. There's various parameters I'd set in place, and as long as all those boxes are ticked, I'd be looking to be accommodating. But again, sometimes you have to know and trust the employee, don't you? And that's another. It's a rather hidden point. And I'm not sure how you test that or how you want that evidenced.
Yeah. Just see the time. It's been such a great conversation, and sadly we have to bring it to a close. We don't have a guest speaker lined up for 2 months hence. And again, it's only because this time I thought this was far more sort of engaging and important that we discuss this amongst ourselves. I'll keep an eye out on what's going to happen after post-elections. Do we have a date on the elections? Sorry, when is it? August?
4th of July, isn't it?
Yeah.
July. Okay, so then because our next roundtable is supposed to happen end of July. Gosh, where's the year going? So I might not be there for that because I'm going to be on annual leave, but I'll sort of speak to Beth. I wouldn't want to miss that. I think it's going to be really interesting post-election. So let's see. But yeah, we'll be in touch. Quite possibly there may not be a guest speaker for that one either.
Maybe we try and get the 3 main candidates on for a mini hustings just on employment issues.
Gosh, Mike.
I have to say, if I was them, I'd say you've got to be kidding.
No, you know what? I mean, the chamber has got the Bank of England to come and talk to us. That was quite a well-attended event, and it's just something to think about. If we can really achieve that, that'll be good. Or even a local Labour, MP to come and talk about. Thank you. Actually, I will take that away and see what we can do with that idea.
Well, I know the 3 main parties have all got their candidates confirmed. So if it's a general note to the candidates just to come and talk to us, well, it would probably be better to talk to the chamber as a whole.
Yeah. I don't think that they would want to talk with a specific focus on the employment law manifesto, but definitely we could but we could ask them to include that as a section, definitely in, when they're talking to chamber members. So I'll take that away. That's a really good idea. Thank you, Mike.
Need a big venue or online because it'll be huge.
It's usually yeah. I mean, these events always at a good venue that John and Beth organize. I think the previous ones we've had have been at the Squaries Winery, so it'll be at a proper venue. But definitely that's something that we could try and organize later in the year. Yeah. But no, thank you so much. Have a lovely rest of the week, and
Thanks,
Sandhya.
Thank you, Sandhya.
Thank you.
Thank you.
Thank you.
Bye.
Speak soon. Bye.
Bye. Bye.